Good morning and welcome. I'm delighted to say that this morning we're going to look at due diligence in residential conveyancing. And a massive thank you to InfoTrack for sponsoring today's event and for inviting me along. One or two things really to talk about before we start. First of all, we are recording the webinar, so I'm sure Bronwyn can make a copy of the recording available to you. There are notes that accompany the presentation, and we'll ensure that those notes are made available. And if you want to have a look at the slides, you're more than welcome to have a look at those. Happy to share them with you, and InfoTrack, I'm sure, will make them available too. As I say, InfoTrack are very good to sponsor events such as this. Do have a look at our website. There's lots of exciting information there, and lots of talk about product, etc., and information about product, which is important. So in addition to sort of sponsoring events such as this and allowing me to drone on for an hour or two, of course, InfoTrack are a provider of all manner of different products, including searches, etc. So if you haven't looked at their website recently, please do so. What I'm going to do today then is talk about due diligence. My name is Quayle from IQ Legal Training, and I spend my life doing lots of work with regard to training conveyancers and also looking at professional indemnity claims and issues with regard to conveyancers. A lot of consultancy work, looking at what we're doing very well, what we're doing not so well, looking at good practice, bad practice, etc. So my plan today is really to share with you some key issues relating to due diligence. The important point here is that I come at this from quite a defensive position. I'm terrified about negligence claims against conveyancers. Why am I terrified? Well, even if a claim has no merit, the amount of time that it takes you to investigate and deal with your insurers is money that's sort of basically down the drain. Secondly, of course, it is important that we understand and appreciate how claims can be avoided. And thirdly and finally, important also to understand that fee earners are aware of what can go wrong with regard to the conveyancing process. So we're talking about residential conveyancing in the main. We'll touch on one or two commercial issues too. We're talking in connection with due diligence about acting for buyers, although I will mention one or two issues that are pertinent with regard to sellers. If anyone has any questions or queries, if Bronwyn will permit, we'll take questions at the end. If we don't have time to deal with questions or you're too shy to raise any questions, to make sure you stay awake, on my last slide, I think there's an email address, and you can drop me a note via that email address and I'll answer any questions that you've got. And if you don't mind, I will anonymize the questions and my responses and allow Bronwyn to share with other delegates any questions and my replies. So first thing, let's have a look at some useful resources. We're not litigators, we are transactional property lawyers, but the PLA website is brilliant for information for property lawyers. There's a case law update section that's kept up to date. I don't know who the editor is, but he or she seems to spot cases that are important. Secondly, and significantly, just about every barrister and KC in the country writes papers and opinions that end up on the PLA website. Everything from seller identity fraud to issues and problems associated with easements and restrictive covenants. So if you have any issues or problems with regard to legal issues relevant to conveyancing, have a look at the site. Have a look at some papers and opinions that have been written. They'll be really useful for you. Everything from sort of notices to complete, issues or problems with first registration, the whole shooting match. The next site that I recommend for one particular reason is a site called Property Protocols. And the reason that I mention it is that there is a boundary dispute protocol on that site, which again is free to access. It highlights the problems associated with boundary identification in residential conveyancing, commercial property transactions, and generally. It highlights what can be done to identify legal boundaries, formal boundary agreements, and determine boundary applications, and also highlights what needs to be done with regard to boundary disputes. And just as with the PLA website, we're not litigators. I'm not encouraging people to get embroiled in litigation if you're a transactional property lawyer, but I do think it's important that we understand what litigation can mean in connection with boundary disputes, the vulnerability as to costs, the potential dangers associated with boundary issues that end up in neighbour disputes, county court actions or high court actions, for example. So Property Protocols has a wealth of information for anything boundary related, which I would commend to you. Something I always mention to practitioners because I think it's so important, the RICS has a consumer guide to surveys and valuations. I don't know if you've seen it, but it highlights the benefits of the various types of surveys and valuations that your client can obtain. It recommends the use of a level 3 survey and valuation, and rather than us in our reporting on title or in our due diligence processes or in scoping our retainer, telling clients about surveys or valuations and the merits of a level 3 survey, refer the client to the RICS consumer guide or provide the client with a copy, and to an extent our job is done. On the issues of surveys and valuations, as I'll show you a little later, it is important that we read surveys and valuations that our client has in connection with the property purchase, but we also limit our retainer with regard to advice that we give concerning surveys and valuations. If we're dealing with leasehold transactions, the Leasehold Advisory Service website, the Leasehold Knowledge Partnership website contain a wealth of material. Yes, the Leasehold Advisory Service is to an extent political. It is criticised from time to time for being biased in favour of landlords. I accept all of that, but what I would say is, despite both of those points, the information the Leasehold Advisory Service site contains is invaluable. Everything from an online calculator to work out the price to be paid on lease extensions, to advice with regard to challenging service charge, advice with regard to dealing with ground rents, advice with regard to law reform concerning ground rents, concerning building safety, etc. It's invaluable. And it's all sitting there waiting for you as a conveyancer to read if you want background about leasehold issues and to highlight to clients, because remember, CQS and good practice requires us to tell clients about the bigger picture relating to leasehold ownership, the rights and obligations owed by landlords to leaseholders, the entitlement of leaseholders to statutory protection with regard to service charge, ground rent, and unreasonable conduct on the part of the landlord. The Leasehold Advisory Service has everything you need in that connection. Leasehold Knowledge Partnership is a site I found relatively recently, to be honest with you. It's political, but I would maintain it's very much biased in favour of leaseholders. So it addresses the imbalance, perhaps, that the Leasehold Advisory Service creates. Very useful for fire safety issues and fire safety measures. Very useful for highlighting bad landlords and bad leases, making sure that practitioners and clients are aware of rights of redress, rights and entitlements, particularly with regard to fire safety. The Association of Residential Managing Agents, which I don't mention here, again, is useful for providing clients with a bigger picture in connection with leasehold ownership. And finally, I mentioned Property Law UK, which is my subscription service for advice produced on a monthly basis. And we've got 35 barristers and specialists that write papers and opinions and case law updates for the profession, which you can have a look at if you're interested. All of those sites are free except the last one. All of the sites except the last one I would commend you have a look at. If you want to have a look at Property Law UK, drop me a note and I'll sort something out for you. Anyway, let's talk about what we're here to talk about, which is due diligence. Imperative in a residential conveyancing transaction that we ascertain client objective. So if I'm your client, Ian, why are you buying this property? And you might get a surprise. I'm buying it because it's for my daughter or my elderly parents to live in. I'm buying it as a buy-to-let investment with one of my business partners. I'm buying it, the obvious answer, to live in it. Okay, there might be some other issues that arise. So I'm buying a flat or apartment, but I'm very interested in the ability to Airbnb let. I'm buying a residential property and I've got a few pounds in my pocket and I want to build a swimming pool and a big extension for a granny flat or something of that nature, or I want a home office at the bottom of the garden. All of these things need careful consideration. All of these things can sway or require us to deal with our reporting on title, our due diligence slightly differently, because there may be issues that are particularly of interest to me as opposed to a traditional ordinary client. There's no such thing as an ordinary client. And further, another important point when we talk about client objective, there's no such thing as a collective client. My partner and I are two individuals that might have different attitudes to risk, might have different objectives with regard to the transaction. All of these things need to be identified. Remember, if we have different objectives, there might be an issue that you can't act on the basis of a potential conflict of interest. So we need to drill down and ascertain the position with regard to all of those things right at the start. And we need to be able to pivot our due diligence We need to pivot what we're going to do with regard to reporting on title, and we need to make sure that what we're doing is achieving the goals or the requirements that this particular client has. We need to know about the target property that's being acquired and any peculiar features relating to it. So, for example, has the property had a boundary altered? Have there been boundary disputes? Is it new built? Have there been recent extensions built to it? What's the position with regard to the locality? Is the property in an urban environment? Is it in a rural environment? If the latter, are we going to have to make inquiries about concerns that our client may have with regard to farming activity or shooting activity in the vicinity that could again impact on our client's amenity? So the important point is that there is a standard set of due diligence that we're going to talk about today, but it might also be necessary, given objective, given location of property, that we have to think about other things too. And this is important with regard to the retainer, it's important with regard to due diligence, and it's important with regard to reporting on title as well. I deal with a lot of negligence claims and looking at what goes wrong. And invariably, I get emails at the weekend from firms that will say, we've just taken this file to have a look at, and think we've got some problems here. What do you recommend? And the important point to avoid claims is to make sure you do the simple things well. Some of the things that we just mentioned at the start there, making sure that we understand where our client is coming from with regard to this transaction. And the other side of the fence, making sure the client understands where we're coming from with regard to our role. That's where the retainer becomes critical. Doing the simple things well will avoid the majority of negligence claims, to be honest with you. Historically, when I was looking at negligence claims, invariably they'd arise from procedural errors. So not registering within priority, not doing the appropriate searches, not reporting to clients adverse entries relating to searches or search entries that impact on objective. These days, you're seeing more and more negligence claims arising as a consequence of poor communication. And again, I was talking to a chief exec of one of the big professional indemnity insurers a few weeks ago. What he was saying was he didn't want to talk about residential conveyancing because the amount of claims they were getting through was huge at the moment, really, as a consequence of what happened during COVID, lockdown, SDLT holidays, etc. A perfect storm that's led to a lot of claims. Communication, effective communication is important. Remember, communication is not a one-way street. It's not you pinging emails and 50-page reports on title and engagement letters listing out the issues with regard to risk, etc. It's more than that. It's making sure that the client reads and understands what we're saying. With regard to risk, it's important that we identify risk and we highlight where further investigation is required, but we also understand, and here's a bit of good news, that we're not meant to be experts with regard to risk. So you're not meant to be a planning expert or an expert on tree preservation orders or an expert on environmental issues. Your job as a conveyancer is to perform due diligence, advise clients as to what due diligence reveals, and where risk is identified, tell the client what that risk is, and then what steps can be taken to quantify it. So with regard to quantification of risk, invariably, what further investigation is going to be necessary, either by the client or you on the client's behalf. And again, this sort of interrelationship between client and you, that's where the retainer and scoping the retainer becomes so important. So when we talk about the retainer, I'm going to show you some case law before we finish today, assuming you're still awake, that highlights some issues with regard to what we need to do. But the key point with regard to the retainer, and the thing I want you to take away today, is to make sure that your retainer is robust. In other words, I as a client know exactly what you're going to do as part of due diligence. I also know what the limitations of what you're going to do are. And I also appreciate and understand what you're not going to do. So this idea about limiting the scope of the retainer is so important. And again, I'm going to show you a horror story with regard to a commercial transaction where a firm was robust in some respects with regard to the retainer, but not in others. So limiting the scope of the retainer is important. Making sure that you're doing work within the retainer and not out with is important. What limitations should be imposed, again, is significant. Explaining to clients the limitations of the conveyancing process. There are some obvious points that need to be made in that regard. The point really with regard to the retainer that I think is so critical is to make sure clients are aware that in essence we're reliant on information and data being provided by third parties. So TA forms are being generated from the seller with all the potential pitfalls that arise. With regard to searches, our search provider is providing searches reliant on third parties, so local land charges departments, etc. Local land charge departments do a brave and good job in the majority of cases, but from time to time they get things wrong. Our clients need to be aware of it. As far as the contractual terms that our client will be entering into when they exchange contracts, it's important to understand that, for example, on exchange of contracts, the seller and buyer are committing to complete on a particular day, but there's no guarantee that completion will in fact take place. So again, we should be providing information with regard to TA forms, searches, contractual terms, etc. We should be providing explanation, and where there is risk, we should be giving advice. In connection with terms of a mortgage offer, it's important that the client understands our role. We can't tell a client where a product is good, bad, or indifferent unless the product is so unbelievably bad that any reasonable conveyancer would be saying to the client, look, you need to get specialist advice from an independent financial advisor about mortgage product because this is so bad. But we should be telling our client that the mortgage will be secured on the property that they're acquiring, and therefore in the event of default there's a risk of repossession. We should be highlighting to client any charges that the lender is generating with regard to the provision of the mortgage, and explaining to clients whether or not there are penalties or surcharges in the event of any default from the buyer's perspective. With regard to surveys and valuations, we should be telling clients about the importance of a survey or valuation, the benefit of level 3 surveys and valuations, and the various other surveys that could be obtained, but the limitations attaching to them. And one of the things that I think is so important, and one of the things that I think is frequently overlooked by conveyancers, is to advise clients of the need to inspect. And when I say about the limitations relating to due diligence and with regard to the retainer, clients need to know that you as a conveyancer will not be inspecting target property. You will be reliant on reading the survey or valuation, if it's made available to you, and the client who inspects target property telling you about what they see when they inspect. So this issue is important. And before I leave this slide, I just want to go over this title here. We are required as conveyancers, as part of the due diligence process, to give our clients information, to provide our client with explanation, and where appropriate to give advice. So let me give you an example of what I mean, okay? In connection with the title that the seller is offering, if a title is registered, the seller will be proudly producing for us a copy of a land registry title plan. And we, no doubt, in our report on title, will be providing our client with a copy of that title plan. We've provided information to the client. In my view, the provision of a land registry title plan is dangerous because it appears to come from an official source, the land registry. It shows the extent of the property being acquired, shown edge red. And there is an inherent danger that our client thinks, that's what I'm getting. Whereas the reality is, courtesy of Section 60 of the Land Registration Act 2002, a land registration plan does not, or a title plan does not reveal the true extent of a registered title. It is a guide or an indicator revealing general boundaries, not legal boundaries, and so cannot be relied upon. So, explanation. Client, there's a title plan, it's a guide, it's an indicator, have a look at it, check to see what you think you're buying when you inspect is consistent with what the title plan reveals, but advice, you can't rely upon it. And further advice and risk. Where the seller is telling us that there's been a boundary dispute with a neighbour, where the seller is telling us that there has been a movement of a boundary wall or a new boundary fence installed recently, that would flag up the need for our client to check that the new fence, the new wall or hedge is located in the correct position. Our client should be told that where we are not clear about the location of a boundary or as to whether the boundary feature correlates with the legal boundary to the property, we can get a report from a chartered land surveyor to assist us, or we could make additional inquiry of the seller to confirm the position relating to the location of boundary, etc., etc. We could even insert a special condition in the contract requiring the seller to prove location of boundary and ownership of the boundary fence or boundary wall. So that's what I mean in practice about information, explanation, and advice. We'll go on and look at that in a little more detail as we progress this morning. So let's start with dealing with TA forms. If I'm acting for a seller, I'm going to tell my client to answer the forms as honestly as possible. I'm going to tell my client, don't think that we can adopt rose-colored spectacles with regard to replies on the basis of overselling the property or hiding things that perhaps could potentially be a problem for a buyer. It's warts and all with regard to what we're telling the buyer. We have to be honest. We have to answer the question. If the seller doesn't understand the question or can't provide an answer or doesn't know, there is a brutal response. I don't understand the question, or I'm not aware of any information to which the question relates. Okay? Attempting to be helpful can be dangerous, particularly where a seller is endeavoring to assist but doesn't really know what the answer to the question is. The seller should be told of their obligation to provide additional information if a reply changes. And where you're dealing with sellers that you don't trust, I would always warn the seller that if they deliberately lie in a TA form, they commit a criminal offence under Section 2 of the Fraud Act 2006. The next point then is from the buyer's perspective. The buyer needs to know that the seller is obliged to provide TA forms or commercial transactions, usual commercial inquiries. The buyer needs to know that the seller should be dealing with the responses seriously and has the potentially liability for misrepresentation if anything is said in the TA forms that is not correct. However, again, back to the point I made a little earlier, it is imperative that clients understand that if the seller lies or makes a mistake with regard to the TA forms, then potentially, unless the seller is willing to volunteer some form of settlement, the only way of dealing with the matter would be to litigate. And actions for misrepresentation are notoriously difficult to succeed with. They will involve expense, they will involve high litigation risk, and the big problem in conveyancing transactions is you've got to prove that that statement induced the client to buy the property. So if the seller is saying the garage roof was recently refelted, and that's incorrect, but our surveyor or valuer tells us that the garage roof requires refelting, then we can argue that no way, as what the seller said, induced the buyer to entering into the contract. So there is the potential for misrepresentation, but I would always tell a buyer that the reality will mean that your client is unlikely to have an appetite to bring proceedings. And if proceedings are brought, there's no guarantee for success. So I always tell a buyer client to use the TA forms as a checklist. In my report on title, as far as due diligence is concerned, I will provide the TA forms to my client, ask the client to check what is said, but advise the client to use the forms as a checklist during client inspection. With regard to Form TA10, I will warn the client that where there is an agreement to purchase fittings that potentially enables the purchase price to be apportioned, the apportionment must be fair and reasonable and must be capable of being substantiated. If not, then there is a risk of fraud being committed against HMRC with regard to SDLT. So TA forms we have to be careful with. I think we set realistic client expectation where we're acting for buyers. As far as searches are concerned, there's some good news, but there's also some bad news. The good news is that A recent decision, which I'm going to show you before we finish today, explains that where we are offering conveyancing at a competitive fixed fee, our client, if he's paying a relatively low fee, can expect a minimal level of service. And therefore, if we are offering competitively priced conveyancing work, as long as we are scoping our retainer so the client understands precisely what they're getting, then we can provide only the essential searches that the client requires. But the bad news, there's no such thing as usual searches. There are searches that are essential. There are searches that are necessary. There are searches that may be advisable. And there may be searches that the client requires us to undertake given their objective. So what do? I would tell the client that the essential searches are search of the local land charges, additional inquiries of local authority, additional inquiries of local authority if the client is buying a property where there is either urban regeneration or the potential for development in a rural area or rural environment. Environmental search and report containing historical land use data and a risk assessment with regard to contamination, decontamination. And if that isn't incorporated within the environmental search and report, a drainage and water search. The important point with regard to those searches are that they are essential. They must be done. Clients need to be aware of why they must be done. For example, local land charges are overriding interests, meaning that they are binding on a buyer whether the buyer client is aware of them or not. Environmental searches and reports are necessary because as an owner of land or even as an occupant of land, you can be liable for decontamination costs associated with contaminated land. And flowing on from that, it is important to understand and appreciate with regard to those searches, there are limitations. So for example, local land charges records are not necessarily kept up to date, and there may be errors with regard to those registers. There are then those searches that are necessary given transaction and client objective. So we're buying a rural property and our client is interested in what sort of farming activity is carried out nearby, or what sort of shooting or other country sports are pursued in the vicinity. Our client might be concerned about the fact that there is an open aspect and beautiful views that the client is buying the property specifically for, in which case there are searches that could be undertaken to determine what's happening with regard to planning in the vicinity. It might be that our client is concerned about wind farms or solar panels in nearby agricultural land and this sort of thing. Our client might be buying a property near to a river or a watercourse, might be buying a property in an area where there's coal mining activity, tin mining activity, gypsum mining, these sorts of things. So again, there are searches that are property specific or transaction specific. Our client might be wanting to build a swimming pool or to excavate a swimming pool, in which case a search that reveals ownership of mines and minerals might be appropriate, because where our client is carrying out investigative work and excavation work, it might be that our client is trespassing on, say, the church commissioners that own the limestone or sandstone beneath the surface of the property when the swimming pool is being constructed. Then finally, there may be searches that the client might like us to undertake if they were aware of what those searches reveal. And this is where InfoTrack come in, because InfoTrack can tell us which searches are available. And I think the thing that we do for clients is we say to the clients, these are searches we've got to do. These are the searches that we think are necessary given what you told us, but here's a list of other searches that are potentially available if you'd like us to undertake them on your behalf. And I think the next point that I mentioned is important. What do we do when search results come back? It isn't enough simply to give the client a copy of the search and say, read it. We can provide a copy of the search in our report on title or as an addendum to the report, but we've got to extract from the search issues that are relevant to client objective or issues that generate risk. We're not then expected to investigate the extent of that risk or how it will impact on client. We've just got to draw to our client's attention that there is risk. So the property, there's an oak tree in the front garden that's subject to a tree preservation order. There's a the property is a listed building. There's some enforcement action being taken in connection with a breach of planning permission. It's this sort of thing. And then telling the client what can be done in order to assess the extent of that risk. Tree preservation order, we could get a report from an arborologist to determine what risk there is or what problems there are relating to that oak tree at the front of the garden. Where we are obtaining an environmental search and the search reveals that the land is contaminated, I don't know, with lead or something of that nature, we can tell the client that we can get an environmental consultant to advise the client as to the likelihood of the Environment Agency requiring that earth being removed or replaced, and the cost of investigative work and the cost of remedial work, this sort of thing. I think it's also important to explain the limitations relating to searches so that clients understand, as I say, local land charges being the obvious one, that local land charges searches are not always accurate. I said I'd refer you to some case law. The first case I want to take you through is this case called Orient Field Holdings and Bird and Bird. An oldish case now, but important. It's important here that the lawyer provided a summary of the effect of the search carried out on behalf of the client. The firm had to advise the client about further investigations that could be carried out. And the firm should have asked the client for instructions from the client in the light of the information and explanation and advice that was provided. So there is risk with regard to planning. There are further steps that can be undertaken by us or by you with regard to the obtaining of a report from a planning consultant that will reveal what the extent of that risk is, enabling you to make a decision whether or not you wish to proceed with regard to this property purchase. So we're not expected as conveyancers to start studying planning and enforcement action. We're required to highlight risk and then say what can be done in connection with assessing the extent of that risk. And that assessment can either be done by us or it can be done by the client. Where the client asks us to do it, then what I would suggest to do things properly is we say to the client, you've instructed us to do this. This is beyond the scope of our existing retainer. This is what we're going to do. This is what we expect to achieve. And this is what we will produce for you. And then after that, it's your decision as to whether or not you wish to proceed. Sounds as if there's an awful lot of additional work there. There may well be. But what you're doing is you're saying to the client, you're going to have to pay for this. AW Group and Taylor Walton, again, a similar thing. This was a commercial acquisition where an enforcement notice had been issued on part of the site. And there were a number of issues, but one of the issues was, had the solicitors identified what their client was intending to do on each part of this site? Probably not. And the court said it was necessary to spell out the obvious and to explain the implications of search results, not just simply saying, there's the search, and then sort of sit back on the basis that's my job done. Again, we go back to this issue. We're providing you with information, the search itself, or our explanation as to the search results. Explanation, what's the significance of consequence of that? An enforcement notice that potentially will be binding upon you on acquisition and could lead to prosecution, appearances in the magistrate's court, etc., etc. Applications for retrospective planning permission. And in order to investigate all of that, let's get a planning consultant or a planning lawyer within our firm to give you advice. And I think this last point is important. We do have to spell out the obvious. We do have to explain the implications of search results. And again, this is something that this case highlights and others highlight. There isn't such a thing as a normal client. Each client has a different attitude to risk, a different level of understanding. And therefore, it's important that we spell out to the client the problem and the choices that are available to them, and that we get instructions. The next thing I want to talk about are sim searches. Sim searches are useful where we're acquiring unregistered land, obviously, but also where we're acquiring a number of registered titles. Do watch in residential transactions, some lenders will insist that a title is composed of one title and won't lend where there is more than one registered title in connection with a property that's going to be security. But a sim search will reveal whether or not registered titles abut one another, or whether, which is not uncommon, there are slivers of unregistered land sitting between registered titles. I would also recommend a sim search where there's problems with boundaries, like I mentioned a little earlier, or where there's a threat of neighbour encroachment leading to an adverse possession claim. So sim searches aren't just for registered land. They are useful where we are dealing particularly with a number of registered titles or where we're encountering boundary problems. Remember what I said about the Property Protocols website and the Boundary Dispute Protocol. One of the things that's emphasised there is that plans, boundaries, statements that are historical, where adverse possession arises, are a waste of time. In essence, what we need to do is look at what the adverse possessor is saying in their statement of truth relating to that application. And just as an aside, promise me to be careful about applications that you make to the land registry to determine boundary, for adverse possession, to challenge unilateral notices, or indeed anything else. Because in the good old days, or the bad old days, depending on how you look at it, the land registry used to refer matters to adjudication, which is sort of an internal process of arbitration within the land registry. These days, they'll refer the matter to first-tier tribunal. The first-tier tribunal will give the parties, or the land registry will give the parties, time to try and achieve a settlement. Where that settlement can't be achieved, the land registry will push the matter to first-tier tribunal. First-tier tribunals are very much the equivalent of county courts with regard to rules of evidence, fairly strict rules of evidence, and there is also high risk relating to costs. If you're objecting to an application and you lose and the applicant proceeds and is successful, you'll be liable for the applicant's costs. And if you're acting for the applicant and someone objects and their objection is successful, you'll be liable for the objector's costs. So the point to make is first-tier tribunals are not sort of tribunals where you can sort of hold a client's hand and take them through the process. I would always advocate that the client instruct a property litigator or counsel to assist them. Local land charges searches. I've mentioned local land charges are overriding interest, therefore binding on a buyer whether the buyer does a local land charges search or not. Binding on a buyer even where they're not revealed by a local land charge. Local land charges are also latent defects in title, meaning that if a seller is aware of a local land charge, but aware that the local land charges register is defective, and therefore a search wouldn't reveal it, the seller would be obliged to disclose its existence to a buyer by way of encumbrance specified in the contract. Additional inquiries of local authority always necessary. Additional inquiries in certain circumstances. And I repeat, because I touched on this a little earlier, where your client is buying a property in an urban context where there's a lot of urban regeneration, or buying a rural property where there's a lot of development carrying out in the vicinity, additional inquiries can be useful. And the reason for that is inquiries will reveal activity adjoining the property or next door to the property, but sometimes there will be activity taking place which isn't adjoining, but nonetheless impacts on your client's use and enjoyment. So the reason that I sort of labour this point is that I dealt with a matter where there was nothing being done immediately adjoining the property, but there was a new park and ride scheme being created, in essence, over the road from the property. Now that park and ride scheme would mean bus traffic and lots of vehicular parking early in the morning as people were commuting to work, etc. And therefore, the park and ride scheme and the car parking relevant to it wouldn't have revealed by inquiries, but would have revealed by additional inquiries, and would impact on use, enjoyment and amenity of the property that was being acquired. Other searches, I've discussed environmental searches, mining searches and everything else. I think it's important to explain to clients the searches that are available so that the client can choose if there are searches that the client thinks they would gain benefit from. And again, collective clients, if you're acting for husband and wife or business partners, each needs to be aware of the searches that could be undertaken, because, as I mentioned earlier, one client's level of understanding or attitude to risk might be different to another's. And I want to focus in on client inspection. Every firm I've ever worked with, worked for, or dealt with has advised clients of the need to inspect target property. happy days. However, firms do not explain the significance of client inspection. So forgive me, that's what I'm going to do now. Clients should be told to inspect before exchange, at exchange in certain circumstances, before completion and at completion. Let's deal first of all with inspection before exchange. Clients should be inspecting to identify state and condition of the property and any planning or building control issues that are revealed. So client needs to have a look round to check that the garage roof has been recently replaced, that there aren't any sort of broken tiles or problems with drainage or guttering that is obvious. They should also read carefully any survey or valuation that's been obtained to determine whether the surveyor or valuer has found anything that would warrant further investigation. The client should also be told to inspect to identify the physical extent of the property, provide with a title plan with the warning that I just mentioned, with a description of the property and perhaps the estate agent's particulars, if it's leasehold, lease plan. And the client should be told, have a look and make sure that what you think you're buying, as per the documentation I've provided for you, is consistent with what you're actually seeing. So the title plan and the description of the property refers to a 1/4 acre of garden, and the reality is that when your client inspects, the garden is triangular in shape and appears to be nowhere near 1/2 acre in size. So the next thing is the client should be told to inspect to identify the accuracy of the seller's replies to TA forms or commercial inquiries. Remember, a seller is obliged to answer additional inquiries before contract where those additional inquiries are relevant to transaction or relevant to buyer-client objective. You can't just raise on every transaction standard additional inquiries. But if your client is asking you questions about the property or what the seller is revealing with regard to the TA forms warrants or justifies further questions, then we should be raising additional inquiries relating to that. Our client should be told to use the TA forms and additional replies to additional inquiries as a checklist to inspect the property. And then finally, the client should be told of the need to identify the existence of overriding interests. And remember, an overriding interest is an interest in land that is binding on a buyer for value, but not noted on the register. Overriding interests may be obvious on inspection. If there are overriding interests that are not obvious on inspection, they are latent encumbrances, which the seller should disclose. The next thing to mention with regard to overriding interest is that you should be providing clients with examples of what overriding interests are. An overriding interest, I repeat, is an interest that is binding on a buyer client, even though it is not noted on the title that the client is acquiring. The client needs to be made aware of the significance of that rule, of that principle, and needs to understand that they have to report to you anything that could perhaps constitute an overriding interest. For example, someone in occupation of the property other than the seller, evidence of a tenancy, evidence of a prescriptive right of way over the land. Anything of that nature should be reported to you so that you can include it in the report on title, or so that you are able to undertake additional investigation on the client's behalf. Client inspection involves clients being bound by anything that they actually see, bound by anything that a reasonable inspection ought to have revealed, and they are bound by anything that the third party who is instructed by the client to inspect sees when they inspect. So clients need to be told what a reasonable inspection involves, inspecting all rooms, all cupboards, attics, cellars, gardens, grounds, any buildings within them, should be making inquiry of anyone in the property other than the sellers and their children. It's also important to ascertain who's inspected the property. Again, I go back to the point I made about co-owners. If one of the co-owners has had a look around and the other one hasn't, it's important that the party that hasn't inspected is aware of the fact that they are potentially bound by what the person who did inspect saw or ought to have seen. Inspection and survey. Again, important that we check lenders' requirements. Clients need to be told about the benefits of surveys. I've mentioned the RICS Consumer Guide. Clients should be told of the need to inspect before exchange to identify state and condition. They should also be told to inspect target property at exchange where the property is empty or prone to vandalism. The reason for that is your client is bound by the state and condition of the property at the point of exchange. So if they haven't inspected at exchange, the seller could say that damage was done to the property the day after exchange of contracts. In other words, that your client in those circumstances would be able to rescind the contract on the basis that the state and condition has altered after exchange. But a seller client, unless they're really honest, is not likely to say that. What they're likely to say is that damage was done before exchange, meaning that your client is fixed with the knowledge of that damage and is obliged to proceed, notwithstanding the apparent change of state and condition since the buyer client last inspected. So we talked about scoping the retainer, making sure that we restrict or limit liability. We highlight the work to be done, highlighting the work that won't be done, highlighting the reliance on third parties, and making sure the client is aware of the limitations of our provision of information, explanation, and advice. So the whole idea of the due diligence process is that our retainer manages that process. And then what the report on title does is sort of reviews before we exchange contracts what due diligence has revealed. The report on title should be consistent with our retainer, should highlight where there are issues that are outside the scope of the retainer or additional work that is being done. You cannot scope the retainer in your report on title. The retainer needs to be scoped when we receive instructions at the beginning of the transaction. When we're reporting on title, there are some key issues relating to due diligence that are important. I think we should highlight client objective. I think we should provide a summary in which we highlight what issues are pertinent to that objective, or where there are areas of risk that we've identified and determined. We should be explaining to clients what due diligence is and what it isn't. In other words, explaining to the client the limitations relating to due diligence. As far as reporting on title is concerned, remember what I said at the beginning of my presentation about the need to be careful about communicating effectively. If we're going to send the client an 80-page report on title or a 120-page report on title, we need to think to ourselves, is our client really going to read this document in its entirety? There are some safeguards that will help us. And what I suggest is, if that's the strategy that we approach, we need our client to confirm that they've received the report on title, that they've read the report on title, that they've understood the report on title, and then we should ask the client if they have any questions at all relating to the report that's been produced. So that at least if in 2 years, 3 years, 6 years' time, the client comes back and said, you didn't tell me about that, we can say to the client, well, hang on, you emailed to confirm you got it, you read it, you understood it. We invited you to ask questions and you didn't respond. Therefore, sorry, Mr. Client, it's too late now to bleat that you weren't aware of this or weren't aware of that. The other route you could take, and again, I still would emphasize we still should be asking those questions or asking for that confirmation for the client, is to produce interim reports on title as the transaction progresses, and then a final report on title before we exchange. To that end, remember, it is imperative that our client has time to read and digest the report. So if I'm exchanging contracts on a client's behalf at 3 o'clock today, and I send a 50-page report on title to my client at work now, you know, what's the reality of my client taking a couple of hours off to be able to read through it? Answer, no reality. It's not going to happen. So the client needs to have time to read it, to consider it, and to respond appropriately. And again, the report on title should be sent out to each individual client where we're acting on behalf of collective clients. Results of due diligence, well, we've talked about it. All are included within the report on title. Again, highlighting risk, highlighting where further investigation has been required or undertaken, and the consequences or results of what has been done. As far as all of those issues are concerned, I said I would touch a little more on survey. I would always warn a client about the fact that I haven't inspected the property. I can't give advice on its state and condition, nor can I give advice on value. That I will read the survey or valuation and deal with any issues that the surveyor or valuer has identified relevant to title. But that's it. On the issue of client inspection, I would, in my report on title, highlight the fact that I've asked the client to check the state and condition of the property, to check for overriding interest, and the client has undertaken an inspection of the property as I've requested and hasn't revealed anything to me that needs to be included in the report. Now, I mentioned clients should inspect before exchange and at exchange. Clients should also inspect before completion and at completion. Before completion, just to make sure it's safe for completion to take place. At completion, because if there are any overriding interests that exist, those overriding interests become disclosable interests at completion and need to be disclosed to the Land Registry on application to register the buyer as proprietor using Land Registry Form DI. So it's important that our report on title provides information flowing from client inspection. It should also highlight title defects and defective title insurance. And again, be careful. Make sure clients understand what defective title insurance does and doesn't do. It doesn't solve the problem. It provides insurance in case a problem generates loss or generates claims for or against the client. And that a title indemnity policy is likely to ensure that our client recovers diminished in value with regard to their property and nothing more than that. Some policies do, some policies don't. It's important that our report on title highlights the responsibility that we have during the conveyancing process, explains the conveyancing process, and provides a summary or conclusion. So, information, explanation, and advice important during the due diligence process. Report on title reiterates these issues, and then we're asking clients for instruction. We're asking clients to confirm what needs to be done or what they want us to do, or that they're happy for us to proceed to exchange of contract. We've talked about the duty. There is a duty to explain process, to explain documentation, to explain vague or ambiguous provision. CQS and SRA requirements are pretty consistent with one another, making sure that clients are not simply told that's what this provision says, but they're provided with an explanation of the impact of that provision. So we should explain documentation, explain searches, etc. Before I finish, there's some case law that I want to look at. I've talked about Orient Field Holdings and Bird and Bird. Modern International Brands and Gately is an interesting case because it just highlights the fact that if we're discussing issues with clients, we need to ensure that we make a file note or attendance note of those discussions. Minikin Landsberg, MBS against Grant Thornton, Chesterton's, all sort of confirming the same point about making sure that we are repeating or reporting to clients search results, highlighting risk, and explaining to clients what can be done in order to determine or assess that risk. The other thing that the case law does is I've referred to a case of Swift against Withers, which is an interesting case about scoping the retainer in a commercial transaction and about just making sure that we're robust in making sure that we and our clients understand what we're doing and what we're not doing with regard to the transaction. Those points are so critical because without having a robust retainer, issues associated with due diligence and issues associated in connection with reporting on title can fall by the wayside. So do have a look at those cases. They make absolutely thrilling bedtime reading. But the important point with regard to the cases, and the good news is, you're not expected to be an expert in all fields. You are a conveyancer. a transactional property lawyer, and therefore there are limitations on what you are required to do. The important point is that the client must be aware of those limitations. So the other cases that I mentioned, as I say, this Moda International. I've given you details in the notes, which you can have a look at. Trial judge was very critical with the conveyancer and his sort of attitude to the provision of information and what the client needed to know. Minkin and Landsberg, again, clients need to understand and appreciate the fact that you are giving advice relating to due diligence and advice incidental to the work that you're doing. But really, the advice is highlighting risk, not quantifying risk. MPS and Grant Thornton that I mentioned was a case concerning the scope of duty that is owed by conveyancers. And in that, I've referred to an unreported case in Plymouth, where a judge was very protective of a firm who were undertaking conveyancing at a relatively low level of fee, with the judge emphasizing this was a basic fee that was being paid and therefore a basic service expected. Normally, what the courts will say is, doesn't matter what you charge, the duty that you owe to the client is the same. This is the first case I've come across, albeit unreported, where the judge was saying, well, this was a basic service and the firm provided a basic service. If the client had wanted a better service, wanted to know about roads in the vicinity of the property or more information about search results, then they should have not gone to a firm that was simply providing a cheap and cheerful conveyancing service for them. It's an unusual case on its own facts, but I've mentioned it in the notes in any event. And I've also mentioned to Chesterton against Oxfordshire County Council, a case that highlights that local land charges searches are sometimes defective. And in this particular case, the search was defective relating to some car parking. And although the client was able to seek redress from the Highways Authority that had produced the information, the important point was that the client was not aware of the fact that the search could be defective and the information that the Highways Authority had could be defective. I've also mentioned AW Group against Taylor Walton, giving you the facts of that case, which I mentioned a little earlier. Rentokil against Goodman Derrick, again, an interesting case highlighting the fact that planning conditions needed to be reported to the client and information and advice given relating to breach of conditions. I've also mentioned Turner Bromwich Jackson Heath concerning co-ownership, great case, lawyers defending successfully proceedings relating to co-ownership. They told the client about what a tenancy in common was. They told the client the fact that a tenancy in common did not mean the doctrine of survivorship applied. And all the information, questions and queries that have been raised by the client had been answered and had been documented. So that's a great case that shows you about the caution that's required relating to co-ownership issues. And then Spire Property in Withers, which is a Court of Appeal decision in 2022. I've given you the citation for the trial, which was 2021. These lawyers were negligent in connection with a commercial case on the basis that they hadn't limited the scope of their retainer. So all of those cases, as I say, make interesting reading. I am conscious of the fact that of time, and I'm also conscious that there's a question, so I'm going to have a look at that question if I can. Right, there are many expert conveyancers such as Tim who criticise conveyancers for raising additional inquiries, especially where they relate to search results on non-legal matters, claiming over many years of conveyancing have never had a claim against them. Where is the balance of due diligence covering our back against minimising inquiries? That's a great question. Okay, let's just have a look at it. The conveyancing protocol does permit you to raise additional inquiries. And those additional inquiries can be raised where there are issues relevant to search results, provided that the information that you are seeking will be within the scope of the seller to produce. Okay, so you can't just ask questions, technical questions about what your search reveals, unless there is a reasonable expectation that the seller will be able to provide an answer. Okay, So the first point is that, for example, where there's enforcement action and you're wanting to know about the likelihood of that enforcement action leading to a prosecution or leading to the requirement for a retrospective planning application, you can't start asking questions of the seller about that. But you could ask the seller about information such as letters before action that have been sent by planning departments or their lawyers relating to enforcement action. So sadly, there isn't an answer, there isn't a cutoff point where I can say they are legitimate additional inquiries that should be answered, and they are inquiries that you should not be raising. I think the point is that where your client requires information, or where you are attempting to assess risk that requires information and you are comfortable that the seller is able to provide it, you can certainly raise the question. The important point here, I think, is you raise the question where the other side won't answer or doesn't provide a satisfactory response. It's essential that that's reported to the client, and then the client told about what further steps or measures could be taken, experts' reports, for example, to try and clarify the position. Great question. Thank you for that. I hope I answered. I haven't really given you a definitive answer because there isn't one, in short. I'm just going to have a look and see if there are any other questions. No open questions, and see if there's anything else in the chat. Right, Jane, I usually send the client that has a summary from InfoTrack at the outset. Yeah, that's great. And I think that's a great product that InfoTrack produce that's really useful. Okay. So if you've got a client buying with a river in the garden, National Rivers Authority search would be appropriate, Jane, in my view. Okay. And again, I've had situations in the past where there have been issues about erosion concerning a riverbank, or I think once I was dealing with someone, there was an oxbow lake that had been left because the flow of the river had changed over the years, and we got a report from a hydrologist about the impact of that. So there is additional work that could be done, Jane, in that connection. Good question. Thank you for that. Bronwyn, I don't know if there are any other questions or any further questions. If there are, feel free to drop me a note at that email address that's shown on screen. And if there aren't, what I'd like to do is to thank you all very much indeed for attending today and for giving me of your time. So I'm going to let you get on and get back to work. Bronwyn, thank you very much on behalf of InfoTrack for setting this up and sitting in the background dealing with IT issues. Thank you very much, everyone, for coming along. All delegates, it's appreciated. Genuinely, any questions, any queries, any issues, drop me a note by email. If I may, I will share the questions, but they will be anonymized to Bronwyn so that she can share with delegates. I think there's another question in chat or something. No problem, Charles. Enjoyed it. Stay safe, and thanks very much for coming along. Thanks, Bronwyn. Thanks, everyone.
Thank you. Thank you.
Bye-bye. Bye-bye.
Bye-bye.
Thank you.
Just to let everyone else know, this session is being recorded in case you missed it, and we will be sharing the recordings later on. And thank you again, Ian. If you do have any questions that you've learned about anything you've learned today, to contact us by telephone or reach out to your account manager, and they will be able to assist you. Thank you so much. Take care.
Bye-bye.
Bye.